Have you ever wondered what kind of proof a police officer has to have in order to pull you over, or give you a citation, or make an arrest? Or how about the kind of proof that it takes to be able to prove that you're guilty in court? Well, this video is going to explain it all. So we have the burden of proof scale. Now this is a scale that's taught universally across the whole United States. Now it's taught at every academy, every police academy, and every law school, but we don't teach it the same. And the reasons are many, but the primary reason is because a lot of the terms are very confusing. Now the law schools teach it the same. The police academies don't necessarily teach it the same. And I'll explain here in a little bit the reasons why. But as a law student, or as a criminal justice student, as a police officer, you need to get yourself a good legal dictionary. Now this is Black Law's dictionary, and the one that I'm going to be using for this presentation. And this is the 9th edition. It doesn't really matter if it's 9th edition, 10th edition. Just don't get the old ones. So you can find yourself a good used law dictionary and get it and study it, especially for the legal terms that you don't understand or that you think you do understand. Double check in a law dictionary, because what's in here is going to be a lot different than what's going to be in a Webster's or another specialty dictionary. So get yourself a good legal dictionary. Okay, so this is the burden of proof scale. At the very bottom of the scale, we have 0 proof. This means you have nothing. You can't even articulate one single fact that somebody did something that they're not supposed to. Very, very low, right? It's 0% probability that he actually did it or did not. The other side of the spectrum, the very top of the scale, is 100%. You can 100% guarantee that this person did or did not do something. Now, even in criminal cases where we get up to close to 100%, it is far from 100% burden of proof, even on the criminal sides. But before we go into that, let's start with the very basics, right? Reasonable, let me get over here. Reasonable suspicion. Now I'm going to be giving you a lot of percentages on the right side, like for example 25%. Don't pay attention to necessarily the specific percent number. It's just giving you an idea on how much suspicion is needed to prove a case. So in this case it would be 25%-ish, which is really not a lot of suspicion. Now reasonable suspicion, according to Black Law's dictionary, and the one that I just showed you, it says a particularized and objective basis supported by specific and articulable facts for suspecting a person of criminal activity. A police officer must have a reasonable suspicion to stop a person in a public place. Okay, this is where a lot of the issues that we're seeing in law enforcement come from, the articulation of reasonable suspicion. Now, an officer has to be able to articulate the reasons why he stopped you in the first place. Now, a civil traffic violation is not reasonable suspicion. That's actually a probable cause for a stop, right? Because you actually committed a violation, or he thought you committed a violation. Reasonable suspicion is significantly lower than that. That's like if I'm driving down the street and I see somebody peeping in a window at a store, can I stop them? Well, I guess it all depends on the facts. Is the store closed? Is it 2 o'clock in the morning? Is the guy covering his face with a mask? Is the guy wearing a hoodie in 125-degree weather? Does he wear gang colors? Do you know him as a burglar? Or have you seen him before? So all those facts come into place on stopping somebody without probable cause. Now that's reasonable suspicion. And the reason why we're seeing a lot of the issues around the nation with reasonable suspicion stops is because they can articulate the reasons why, but it's not clear enough. Those reasons aren't clear enough. Or they might say, well, he's dressed in gang colors. Well, I like blue. Am I a gangster? No, right? So you have to be able to articulate the reason why you think it's very suspicious. And that's a reasonable suspicion. But it's really not that hard to wait to see if you have probable cause for a stop. Now, probable cause is set right here in the middle, around 51%. So it's 51% likely that the person committed a crime. So this could be a civil crime or it can be a criminal crime, right? It's a crime. So it's a 51% probability. Now, probable cause, as black law defines it, a reasonable ground to suspect that a person has committed or is committing a crime, or that a place contains a specific item connected with the crime. Now that's for search warrants. Under the Fourth Amendment, probable cause, which amounts to more than a bare suspicion, right? It's reasonable suspicion. So it amounts to more than a bare suspicion, but less than evidence that would justify a conviction. Must be shown before an arrest warrant or search warrant may be issued. Now, probable cause is a little bit more detailed, right? You have to have very specific facts. In the case of a traffic stop, well, your probable cause for the traffic stop is going to be, the violation, right? It's 51%. Now, for an arrest, you just have to tip that scale, right? Just 1%. Is it likely that that person committed a crime? And the officer has to be able to articulate those reasons. If you punched your neighbor in the face, right, and you said, I didn't do it, and your neighbor said, well, yeah, he did it, is that probable cause? No, not really. You have to have a lot more than just a he said, she said kind of situation. Now, maybe there's a surveillance camera that shows you punching him in the face. Is that probable cause? Yeah, absolutely, and it proves that you're a liar. Or let's say there's two independent witnesses. Two other neighbors came out and said, yeah, this guy, he punched this other neighbor in the face. Is that good? Yeah, it definitely can be. So you have to do your digging to get up to that 51%. Now, just because you have that 51%, it just means you have probable cause and you can make an arrest. Now, can you be convicted of a crime based on 51%? Absolutely not. We haven't even reached that standard yet. So let's get going on the other standards. Now, officers will typically make an arrest right at 51%. And what that does is it doesn't allow you to do your investigation enough to get to a different standard to be able to prove your case in court. So a lot of these cases that you're like, why did this court dismiss this criminal case? Well, it's probably because the officer didn't do enough on the back end of his investigation or right at the beginning of his investigation to be able to prove that case later. So as an officer, take your time, and just because you have probable cause, it does not mean you have to make that arrest right then and there. Do your investigation. And we'll talk a lot about investigations later. Okay, so the next thing is preponderance of evidence, which is right at about 51%. Okay, so that's a civil term that we use a lot in the civil world. So if you're stopped for a civil traffic violation and given a ticket, you are going to go to civil court. They're going to find you responsible if you did it. Not guilty, responsible, right? Different terms once again. So the preponderance of the evidence says the greater weight of the evidence, not necessarily established by the greater number of witnesses testifying to the fact, but by evidence that was the most convincing force, superior evidentiary weight that, though not sufficient to free the mind wholly from all reasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. This is a burden of proof in most civil trials, in which the jury is instructed to find for the part that, on the whole, has the stronger evidence, however slight that edge may be. Now, that's a little bit of a really long explanation of the preponderance of the evidence, but it pretty much just says if they can prove that you did a violation, then you are going to be responsible. That's preponderance of the evidence. Very low very low standard. Once again, it's 51%, and that is what they're going to use in civil traffic. Now, let's go on to clear and convincing evidence. This is my favorite because this is where I used to play a lot when I did civil, a lot of civil cases for the police department, is clear and convincing evidence. Now, clear and convincing evidence is a little bit different. It's about 75% likely that that person committed a crime, right? Or in a lot of the asset forfeiture type cases, that item, that asset, was involved in some type of criminal activity. Now, clear and convincing evidence is defined as evidence indicating that the thing to be proved is highly probable or reasonably certain. This is a greater burden than preponderance of the evidence, the standard applied in most civil trials, but less than evidence beyond a reasonable doubt, the norm for criminal trials. Now, when I teach criminal law and even civil law in the police academy and to lawyers across the nation, what I like to do is teach them how to always, no matter what, reach that clear and convincing evidence, even in their civil cases. It makes their civil cases that much better if you can reach clear and convincing evidence. Before they make an actual arrest, an officer, I like to get them at least to clear and convincing evidence. Can the evidence point to exactly, whoops, I hit my little mic. Can the evidence point exactly to what you're trying to persuade a jury to see? Do your investigations. I'm very big into investigations, and if you make an arrest at 51%, the likely it's going to be thrown out or dropped in the future is very high because you haven't reached that pretty much that clear and convincing evidence. Once you reach that clear and convincing evidence as a police officer, then the lawyers can make up the other grounds to get to the next step, which is beyond a reasonable doubt. Now, beyond a reasonable doubt is not 100%, no matter what they teach in high school. It's not even 98%. It's really around 90%. So is it 90% likely that this person committed a crime or not? Now, once again, the percentages don't really matter. It's just giving you an idea of the types of burden of proof and where they fall on the scale. But in all reality, you need quite a bit to convict somebody beyond a reasonable doubt. Now, Black Law Dictionary, once again, oops, sorry, my phone, it went off. So Black Law's Dictionary defines beyond a reasonable doubt, and yes, that was a theme song from Robin Hood. Beyond a reasonable doubt as this: the doubt that prevents one from being firmly convinced of a defendant's guilt, or the belief that there is a real possibility that a defendant is not guilty. Beyond a reasonable doubt is the standard used by a judge to determine whether a criminal defendant is guilty. In deciding whether guilt has been proved beyond a reasonable doubt, the jury must begin with the presumption that the defendant is innocent. It's completely useless if the jury goes in thinking the defendant is guilty, right? It kind of disproves the whole criminal justice system. So it's really important that you do have an unbiased jury at the very beginning to be able to prove beyond a reasonable doubt that somebody committed a crime or not. Now, is beyond a reasonable doubt 100%? Absolutely not. Like this scale says, it's around 90%. Does that leave a little bit of wiggle room for innocent people to be convicted? Absolutely. Why? Because the prosecution only has to prove their case up until about 90%. Is it 90% likely that the person committed a crime? Yes or no? And if the answer is yes, that person will likely be convicted of that crime, even though he's claiming or he may have not even committed that crime. But the facts prove around 90% that he did do it. I hope you enjoyed this video on burden of proof. Now, if you have any kind of questions or comments, please leave them in the comment section below, and I'll try to get back to you as soon as I can. This is one of the most important topics that we can teach in the police academy and in law schools. And the reason why is it really stresses the importance of definitions, legal definitions. Make sure you understand the legal definitions of what you are talking about. If you don't, it's going to be very confusing and actually confuse not only your client, or it could confuse your agency. So get yourself a good law dictionary. Double check all your legal terminology in a law dictionary versus a traditional standard dictionary. I hope this video helped, and once again, if you have any questions, please leave them below. Have a great day.